continue this all day, I also would add you to the case if you want to continue this. This needs to be dismissed today.
This district court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you hear it this time.
Yes, Your Honor. Javar Grayson represents.
All right, buckle up. We're back in Judge Coleman's courtroom for round 2 with sovereign citizen Jabber Grayson, the self-proclaimed free traveler on a mission to outsmart the law. Armed with YouTube logic and misplaced confidence, he's ready to challenge not just the traffic system, but the officer who stopped him. What follows is pure courtroom chaos, confusion, defiance, and a front row seat to legal delusion colliding with hard reality. Judge Coleman stays sharp, no nonsense, and ready to dismantle every baseless claim with precision.
To you as
Good morning.
well. All right, I see that there is let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You're telling me that the court doesn't have jurisdiction, and you're not sitting into the jurisdiction of the court. And why are you filing something in this court if you believe the court doesn't?
On one side stands Officer Brian Ambrose, backed by attorney Christopher Michaels. On the other, Jab Grayson, representing himself and claiming Moorish American sovereignty while denying the court's jurisdiction. In essence, he's telling Judge Coleman, "You have no power over me," yet still demanding a default judgment from that same court. The contradiction is glaring. You can't reject the law and then expect it to serve you. Judge Coleman's challenge: stay calm, stay procedural, and navigate the chaos without letting it derail the courtroom.
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer. Sir, go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who is representing this police officer filed its motion back in June, dismissed in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is a was at the time and still is a police officer. He'd be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any.
Here's where the paradox hits full force. Jab Grayson denies the court's jurisdiction while simultaneously demanding rulings from it. Classic sovereign citizen contradiction, rejecting authority, yet begging it for validation. Judge Coleman, visibly unimpressed, points out the obvious. If you don't recognize the court, why file here at all? Then comes the procedural takedown. The judge explains that a default judgment only applies when the other side fails to respond, and Officer Ambrose did, right on time. Motion denied. It's a clean, factual dismantling of Jab's fantasy law. The gap between real legal procedure and sovereign mythology couldn't be clearer. And with governmental immunity shielding the officer, Jab's case collapses under the weight of its own confusion.
Certainly, let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default or
take a moment to absorb the absurdity here. Jav's entire case stems from a traffic ticket twisted into a right to travel crusade. What should have been a simple citation has turned into a maze of sovereign jargon and self-made legal fiction. Judge Coleman, patient as ever, tries to follow the nonsense while the courtroom struggles not to laugh. This isn't law, it's courtroom theater at its peak. So here's the real question. If you were the judge, would you entertain this circus or shut it down on the spot? Because cases like this don't just test legal logic. They test patience, reality, and common sense all at once.
No, for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, straight there, if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic. I guess is a some type of traffic ticket. I started off Brian Ambrose's stopping me, and I believe I have the right to travel.
Here's the turning point. Judge Coleman cuts through the chaos with sharp precision, dismissing the complaint without prejudice, meaning Jav can refile, but only with a claim that actually exists under Michigan law. He makes it crystal clear. Yes, there's a right to travel, but it doesn't override traffic laws or police authority on public roads. This is judicial patience, clashing with pure absurdity, and winning. The courtroom gets clarity, Jav gets a crash course in legal reality, and the session ends with a quiet but decisive reminder. Law isn't optional. It's absolute.
And I do understand the default judgment, that you are saying, and what it's pertaining to. We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's action being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Hey, yes, very briefly, there was nothing filed by plaintiffs. And it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing.
Just like that, another sovereign citizen fantasy collapses under the weight of real law. No birthrights, no right to travel, and definitely no default judgment. When ideology collides with statute, law always wins. From start to finish, it's the perfect storm of arrogance meeting order, a blend of tension, irony, and cold, hard legal reality. This is the courtroom, not a stage for personal beliefs. Here, facts outrank feelings, and no amount of wordplay can bend the rules of justice.
All right, I got it. All right, and that you felt the state of action upon which the court can grant relief. This case and the complaint in this matter will be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file.
Sum it up. Jav Grayson filed a baseless civil complaint against Officer Ambrose, waving the usual no jurisdiction and right to travel flags. But Judge Coleman swiftly shut it down, dismissing the case without prejudice and schooling him on procedure, immunity, and reality. A clean win for law and order, and another sovereign citizen fantasy crushed by cold, hard fact. If this courtroom chaos shocked or entertained you, hit like, drop a comment, and subscribe for more unfiltered courtroom reality.